सोर्सेस अफ ल एलएलएमको तयारीको लागि साबर गरेको छु फन्डामेन्टल नलेज अफ लबाट The meaning of sources of law. The meaning of the term sources of law differs from writers to writer. The positivists use the term to denote the sovereign or the state who makes and enforces the laws. The historical school uses the term to refers to the origins of law. Others use it to indicate the causes or subject matter of law. Professor Fuller in his Anatomy of the Laws state that a judge interprets and applies certain rules to decide upon a case. Such rules are obtained from various places which are known as sources. Here he further goes on to give examples of the common sources of law such as codified laws, judicial precedents, customs, justice, custom jurist writings, expert opinion, customs, jurist writings, expert opinion, morality and equity. Morality and equity. Holland has defined the terms to mean the sources of the knowledge regarding law. According to Salmon, there are two main sources of law: formal and material. Formal sources are those from which laws derives its validity and force. It is the will of the state, which is expressed through statutes and judicial decisions. Is divided the material sources into legal sources and historical sources. Legal sources comprises of legislation, precedents, customs, agreement, and professional opinion. Caton said that the sources of law have emerged as a critique of Salmon classification. He defined the term as those materials from which law is eventually fashioned through judicial activity. He classified the sources of law into binding sources and persuasive sources. Binding sources and PRSUASIV, persuasive sources. Binding sources are those which have to be necessarily followed by the courts. Legislations, judicial precedents, and custom are example of such sources. Persuasive sources are those which come into play when there is absence of any binding sources on any particular subject. Foreign precedents, professional opinion, and principle of morality or equity are example of persuasive sources of law. Austin said that the term sources of law has three different meaning. The term refers to immediate or direct author of the law, which means the sovereign in the country. 2. This term refers to the historical document from which the body of law can be known. 3. The term refers to the causes that have brought into existence the rules that later on acquire the force of law. For example, customs, judicial decisions, equity, etc. Those things which directly and indirectly plays roles in the formation and development of laws are called sources of law. There are various sources of law, but there are two major sources of law. They are 1. A. Direct sources of law, and B. Indirect sources of law. Direct sources of law, legislation, precedent, customs and conventions. Legislation, precedent, custom and convention. B. Indirect sources of law, juristic writings, reasons, equity, justice, and good conscience. Good conscience. After given direct and indirect sources of law, its discussion and elaborations came as below. Direct sources of law, primary sources of law. 1. Legislation, meaning and kind of legislation. Legislation means the process of lawmaking. Legislation is composed of two words, legis and latum. Here, elegia is legis and latum, latum. Here, legis means law and latum means making. Latum means making, and as a whole it means lawmaking. According to Austin, it means the making of law by a supreme or a sovereign authority which must be followed by people of every stratum of the society. Salmon defined legislation as a process of lawmaking by a competent and able authority. Legislation is a process of lawmaking where a competent authority is given the task of drafting and enacting the laws in a state. It is also said to be a strict concept of lawmaking because there is only one body which is entrusted with the work of lawmaking, and also there is no scope of any alterations as such because of codified and watertight laws, codified and watertight laws, which leaves a very minuscule, minuscule, minuscule range of the amendment, minuscule range of the amendment. According to Salmon, legislation is that source of law which comprises in the assertions of law full standard by a competent specialized. According to Austin, legislation is the command of the sovereign or the superior authority which must be followed by the common masses backed by sanction. According to Gray, legislation implies the formal expression of the administrative organ of the general public. According to positivist school, a run of the mill law is a rule and legislation is the typical source and form of lawmaking. Most example of this school don't affirm that the courts additionally can figure law. They don't concede the case of customs as a wellspring of law. Consequently, they view the just legislation as the form of law. According to historical school, the legislation is the least innovated. The legislation is the least innovative of the forms of law. The authoritative motivations behind the legislation. The authoritative motivations behind the legislation is to give the better for framework and increasingly viable the custom which is unexpectedly created by the general population. Historical school usually doesn't perceive the legislation as a form of law. Types of legislation. Legislation can have numerous reasons, for instance, to direct, to approve, to endorse, to give, to authorize, to allow, to proclaim, to confine, and to annul. Therefore, in acting any legislation and the rule of law, the welfare of the citizen must be kept in mind, and therefore it is must be adopted in the best interest of the citizen. Some different type of legislation are as follows: supreme legislation and subordinate legislation. Supreme legislation. The supreme legislation is the legislation adopted by the sovereign intensity of the state. In this manner, some other authorities which are the organ of the state cannot control or check it. It is considered incomparable as well as lawfully powerful. An established piece of this rule can be found in Dicey Book, the law of the Constitution. There is no legitimate restrictions on its capacity. Indian Parliament is likewise preeminent, even though there are different constitutional amendments on its capacity. It isn't subject to any other administrative authorities inside the state. Therefore, the sovereign jurisdictions of the state can't be revoked, cancelled, or constrained by some other authoritative organ of the state. Subordinate legislation. Subordinate legislations will be legislation by some other authority then the supreme specialist in the state. It is made under the power designated by the supreme authority. Such legislation owes its reality, legitimacy, and continuations to the supreme expert. It can be cancelled and abrogated anytime by the power of the sovereign authority, and therefore it must offer an approach to sovereign legislation. Subordinate legislation is liable to parliamentary control. Five unique type of subordinate legislation can be distinguished. There are as follows: colonial legislation, executive legislation, judicial legislation, municipal legislation, and autonomous legislation. Colonial legislation. The nations which are not autonomous and are used the control of some other state have no supreme capacity to make law. Such countries can be in different classes such as colonies, domains, secured or trust regions, and so forth. The laws made by them are subject to the supreme legislation of the state under whose control they are. Therefore, it is subordinate legislation. Executive legislation. At the point when the legislative powers are delegated by the designed, at the point when legislative power are delegated by the designated officials to an executive, it is called executive legislation. Even though the significant capacity of the official is to execute the laws and carry on the organization. He or she is continuously dependent on some subordinate enactment power. Today, for all intent and purpose of each law sanctioned by the lawmaking body contains assignment statement giving lawmaking power by the official to the executive in order to enhance the statutory arrangement. Judicial legislation, power delegated to the judicial system to make and implement their own laws to maintain transparency in the judicial system of the country. This will also ensure that there is no involvement of any other organ of the government in the governance of the judicial system of the state. Municipal legislation, municipal bodies are offered power to make bylaws concerning their neighborhood matters by law made by a neighborhood body works inside its individual area. Along these lines, there is a plausibility, 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 plausibility of extensions of this sort of subordinate enactment in our nation. Autonomous legislation, at the point when the supreme authority gives powers upon a gathering of people to administer on the issue dependent to them as a gathering. The law made by the last is known as the autonomous law, and the body is known as a self-ruling body. A railway is an independent body. It makes bylaws for the guidelines of its organization and so on. A college is likewise a self-governing body. Even some universities in India have been granted the status of autonomous bodies. Delegated legislation, delegated also known as subordinate legislation, is legislation made not directly by an act of the parliament but under the authority of an act of the parliament. Under the authority of an act of the parliament, parliament has regularly and extensively delegated to the executive government limited power to make certain regulations under acts. Where acts are made by parliament, a principles act may cause agreement for subsidiary legislation to the made and will be indicate who can make laws as such under that act. Delegated legislation can take a multitude of forms, and this list is not exhaustive. The legislation acts use the term legislative instrument to cover the wide range of delegated legislation. Although specific type of delegated legislation are excluded from the definition of legislative instrument and thus from the application of the act. It might be directed by government department, local council or courts. Precedents, meaning and kinds of precedents. In general English, the term precedents means a various instance or case which is or may be taken as an example of rule for subsequent cases, or by which some similar act or circumstances may be supported or justified. A precedent is a principle or a rule that was declared or laid down in a previous legal case. It is binding or advisory on tribunals and courts when a similar case with similar facts arises before it. There are nothing that previous legal decisions that have been made by judges in similar cases in these cases courts that provide an outline as to what must be held in similar cases that arise before the court, or similar cases that arise in lower court, or similar cases that arise before a lesser bench. According to Salmon, in a loose sense, it includes merely reported case law, which may be cited and followed by courts. In a strict sense, that case law which not only has a great binding authority but must also be followed. According to Bentham, precedents are judge-made law. According to Austin, precedents are judiciary laws. According to Gray, precedents cover everything said or done which furnished a rule for subsequent practice. According to Caton, a judicial precedent is judicial to which authority has in some measure been attached. Which authority has in some measure been attached. According to Black Law Dictionary, rule of law established for the first time by a court for a particular type of case and thereafter referred to deciding similar cases. In general, in the judicial field, it means the guidance or authority of past decisions for future cases. Only such decisions as lay down some new rules or principles are called judicial precedents. The application of such judicial decisions is governed by different principles in different legal systems. These principles are called uh, doctrine of precedence. For the case to be held, first such precedents must be reported, may be cited, and may possibly be followed by court. Secondly, the precedents under certain circumstances must be followed. Elements of precedents: obiter dicta and ratio decidency. Elements of precedence: obiter dicta and ratio decidendi. Obiter dicta is a Latin term which means things said or opinion given by judges while making decisions. These opinions are not binding on all the other courts, while they are only persuasive in nature. 2. Ratio decidendi. Ratio decidendi is taken from a Latin term which means reason for decision. Ratio decidendi is binding on all the lower court of the country. Doctrine of Stare decisis. The doctrine of stare decisis. Stare decisis is a legal principle which requires judges to abide by the respect the precedents laid down by similar prior decisions. The Latin maxim stare decisis et non quota movere, which means to stand by decision and not disturb the undisturbed form, the basis of the legal principles in the legal context. Judges interpret as meaning to do not disturb already settled matter to allow for continuity. If varying judges gave their opinion in different matters in different courts having similar facts would lead to chores and chores, and many parties would feel like their rights have been infringed and they would feel helpless and like justice has not been served to them. This doctrine is basically a rule or a requirement that a court must follow the rules established by a Supreme Court. Verdict that need to be seen as for having a binding precedent is not valid in most civil law jurisdictions, as it is seen a mere reading of the text as interfering with the right of judges to interpret the law and the right of the legislature to frame the law. Type of precedent: binding precedent, persuasive precedents, original precedent, binding precedent. Binding precedents are also known as authoritative precedents. These precedents are bound to be followed by a lower court or other equivalent court once a judgment is made, whether they approve it or not. To persuasive precedent. Persuasive precedents includes decisions taken by an inferior court at a higher court or any other court is not obliged to follow. It depends on the court to decide whether to consider it or not. In next words, here the precedent is not necessarily needed to be followed. The judge will rely heavily on this case and take it into consideration. It is not directly considered as a source of law, but it seems as a form of historical precedence. This is usually seen in high courts, where the judges in one high court can be considered as persuasive precedents in another. This can be seen when similar cases arise in various high courts. The verdicts can be made by relying upon judges from other high courts. They will not be binding but will be persuasive and will act in favor of the litigating party in whose favor the previous verdicts have been made. Original precedent and original precedence arises when the court has never taken a decision in a case and it has to use its own direct discretion to reach a conclusion. It helps to create new law in declaratory precedents. The made applications of a rule in a previous legal case is used. Original precedents result in the creation of new laws. Here new laws are created and applied An example can be where we consider that the power to amend the constitution was not restricted till it was decided that limits must be placed on the same, and that all laws in the ninth schedule henceforth must also be tested against the basic structure. For declaratory precedence. The declaratory precedence is applications of existing precedents in a particular case. A declaratory precedence involves declaring an existing law and putting into practice, hence it does not help in creating new law. Nature of judicial precedents: they must be purely constitutive and not abrogative in nature. Hence, while a judicial decision can make a law, it cannot alter it. When there is settled rule of law, the judge must adhere to the same. The judge cannot substitute their opinions for the established rule of law and make decisions based on what they think should be happening, should have happened, or could have happened. The function of the precedents is limited to supplying the vacancies of the legal systems by filing up with new laws the gaps that exist. Importance: the primary function of the judiciary is the settlement of disputes. Initially, while adjudicating, the court are guided by customs and their own sense of justice. Later on, legislations become the main source of law, and the rule of law is what judges base their decision on. One individual method: deductive method. Individual method: a great amount of reliance is placed upon the decision of the judges. In this method, the judges look into previous cases in the same or superior court before giving a final judgment of a similar nature and have already been adjudicated upon before. They consider general rules and principles from the previous case and apply them on the cases before them. They have decide accordingly. This is known as the inductive method. 2. Deductive method. In this method, a great amount of reliance is placed on a legislature and the enacted statutes. It can be seen as a kind of positivist approach, but most judges are now free to interpret the law in any way they see fit to favor justice, equity, and good conscience. In such a system, the cases are decided on the basis of the enacted legislation and statute that are codified, and the judges decide cases on the basis of these statutes. Here, the judges do not decide on the basis of previous decided cases. Custom, meaning and kind of custom. The word custom is derived from an old French word costume, C-O-S-T-U-M-E. Some says that the word custom is based on Latin word consuetude, C-O-N-S-U-E-T-U-D-O, C-O-N-S-U-E-T-U-D-O, C-O-N-S-U-E-T-U-D-O. In Nepal, the word custom means riti, R-E-T-I, Behvar, B-Y-A-B-A-H-R, or Riwaz, R-I-W-A-J. Custom is a primary source of law, and it is the oldest form of making law. Law based on custom is known as customary law. In primitive society, the lives of human beings are regulated by custom. It is unwritten law created by human beings. Customary law also plays important role and fills gap where there is lacking of law. Nepalese law has accepted some custom which have legal authority. For example, marriage is kin relation is prohibited in Nepal, but Muliki Civil Code 2074 Section 70 subsection 2 Section 70 bracket 2, notwithstanding anything contained in clause B of subsection 1, nothing shall be bar the conclusion or causing the conclusion of a marriage within the relationship that is allowed to marry in accordance with the practices prevailing in their ethnic community or clan. Custom is an important source of law, and it is desirable to define the same. Custom has been defined by various jurists or as per their notion, understanding, philosophy, views, and opinion. Various jurists have conflicting views in considering custom as a source of law. John Austin, who is a positivist, states that custom are not be considered as a source of law, as this is not created from the will of the sovereign, whereas F.K. von Savigny, F.K. von Savigny, Savigny, consider custom as a source of law. In fact, according to F.K. von Savigny, custom is the most important source of law as this follows the will of the people, and the will of the people is greater than the will of the sovereign. The different jurists also define custom on the basis of source, validity, practice, history, utility. Some of the important definition of custom are as follows. Austin, according to Austin, custom is a rule of conduct which the governed observed spontaneously and not in a pursuance of law set by a political superior. According to Alain, custom as the uniformity of habits or conduct of the peoples under like circumstances. Holland, he defines custom as a generally observed course of conduct. Halsbury, custom is some kind of special rule which is the actual existence and possibles followed from time immemorial and which has acquired the force of law in a specified territory, although it may be contrary to or inconsistent with the general law of the land. According to John Salmon, custom is an embodiment of principles of justice which have applied to the national conscience. During ancient times, customs were considered as the only source of law, and even now, when a law is implemented, if there exists a custom which goes against the newly established laws, then the principle then the people who follow this custom will be given an exception to that particular law. Classification of custom: legal custom and conventional custom. This custom have been described as below. Legal customs: the legal custom are those whose legal authority is absolute and unconditional. Legal authority is absolute and unconditional. These customs operate as a binding rule of law. They have been recognized by the court and have become a part of the law of the land. They are enforced by the courts. Legal customs are of two types: general custom, local custom. General customs, these customs are prevalent throughout the territory of a state, and the general custom constitute one of the source of the common law of the land. They are considered to a part of the law of the land. Local custom is that which prevails in some defined locality, that is to a district, towns, or an area. In next words, these customs are applicable only to a particular locality like city, village, district, etc. These are geographical local custom and personal local custom. This custom of particular localities are recognized by the courts even in derogations of the common law. B. Conventional custom. A conventional custom is also called uses. USAGE. It is an established practice whose authority is conditional on its acceptance and incorporations in the agreement between the parties bound by it. In simple words, a conventional custom is conditional, and condition is that it will be binding on the parties only if it has been accepted and incorporated by them in the agreement. Requirement of a valid custom: each and every custom cannot be legally enforced. They must be provided before the courts like any other thing before they can have the force of law. The following are important elements of a valid custom. One, immemorial antiquity, ANTIQUITY, immemorial antiquity. Reasonableness, immemorial antiquity. Reasonableness, conformity with statutory law, morality, certainty, observance, continuity, peaceful enjoyment, binding or obligatory force, public policy. 1. Immemorial antiquity. The first element of a valid custom is that it must be immemorial, it must be old or ancient, and must not be of recent origin. To reasonableness, a custom ought to be reasonable. Whether a particular custom is reasonable or not shall depend upon the discretion of the court. This is one of the most difficult question. What is reasonable? Ellen said, seems to be uh, not that a custom will be admitted if reasonable, but it will be admitted unless it is unreasonable. The divisional code of the king is bench define a fair and proper, and such a reasonable, honest, and fair-minded men would adopt. 3. Conformity with statutory law. In order to be valid, a custom must be in conformity with statutory law. Most of the legal system of the world have laid down a rule that a custom can be abrogated. Custom can be abrogated by a law passed by the legislature. However, in some cases, a custom can even override the codified law. For morality, mostly customs are on the basis of morality. 5. Certainty. Custom must be certain. A custom, however ancient, must not be indefinite and uncertain. Certainty is an indispensable condition of a valid custom. Unless a custom is certain, it cannot be proved to have been time out of mind. When we told that custom must be certain, that relates to the evidence of a custom. Observance. Custom must be followed by the all person. Custom must be followed by the all person. Continuity. In order to be recognized as a custom must be practiced continuously. 8. Peaceful enjoyment. A custom should have been enjoyed peacefully in the society in order to be recognized as law. 9. Binding or obligatory force. Blackstone stated that a custom must be supported by the opinion necessitates the public which is affected by the usage must treat it as obligatory and not a facultative one. 10. Public policy. A valid custom should not be opposed to public policy. In this sense, public policy implies this principle on which the social laws are based. For conventions, convention is an agreement between two or more than two countries. Convention is an agreement by which two or more countries try to establish relationship between them governed by international law. Treaties and convention are one of the most important sources of international law. This convention can be multilateral or bilateral. Multilateral convention relate to the treaties which formulate the universal or general application of the law. On the other hand, bilateral convention are those which is formed exclusively by two states to deal with a particular matter concerning this state. It is primary source of law because the Constitution of Nepal 2072 Article 278 and 249 has provision about treaty, and the Treaty Act 2070 state that the treaty law shall be applied as state law, and if state law inconsistent with treaty law, and the treaty law may prevail. Convention is an agreement between two or more than two countries. Nepal is a party of various conventions like CRC, CEDAW, etc. and so on. Therefore, it is clear that convention is primary source of law. Be it indirect sources of law, secondary sources of law, jurist writing, reasons, equity, justice, and good conscience. Indirect sources of law are also called secondary sources of law. It is not binding in nature. People are free to follow or not. Jurist writings, those people who have depth, knowledge, and experience in their own professions and field can develop an idea to relate authority. The genuine writing of the law experts, scholars, jurists, lawyers, judges, and law teachers are example of the jurist writing. It has not binding forces. For example, opinion given by lawyers, judges, doctors, and engineers, etc. Jurist writing are as follows: international law, Hugo Grotius; country justice, Dalton; international law, Hugo Grotius, country justice Dalton, the concept of law Achille the concept of law Achille reason means the legal explanation of a court judgment. Reasons can be given either in writing or in verbal form. It is not necessary that every judgment must be associated with a reason. Reason is also a secondary source of law. Reasons play important role in lawmaking. For example, it is legally prohibited that not to get married in close blood relations due to scientific reason. Equity, justice and good conscience. Justice, equity and good conscience have legally been interpreted as common law and rules that are applied when any written law is not applicable to a legal matter. The court also uses justice, equity and good conscience in the absence of law in matter relating to personal law. Equity, justice, and good conscience are closely related with social and natural justice. Basically, equity, justice, and good conscience are dependent upon the discretionary power of judges, which they could use in the decision of the court. Thank you. God bless you all. मेरे चैनल सब्सक्राइब कर दिनुहोस्.